Hi and welcome to LawLeeks. Today we will be looking at what Brexit would mean for British sovereignty, but first we will be looking at the EU's claim to supremacy and Brexit before looking at how the UK plans to regain parliamentary sovereignty. Please make sure to like and subscribe to our YouTube page for more videos. The EU was established after the Second World War to create unity between France and Germany, which lays out the foundations of the EU 4 decades later. The EU originates from European Coal and Steel Community and the European Economic Community, which were formed in 1951 and 1958 with the alliance of France, Netherlands, Belgium, Italy, Germany and Luxembourg. It wasn't until 1993 where the European Community changed its name to the European Union and grew in size, with new member states joining. The constitutional basis of the EU was changed and improved after the Lisbon Treaty in 2009. The EU is an economic and political alliance with 28 countries. All countries are independent from the Union, but have all agreed to trade under agreements and made between each other. During the 1960s, the EU witnessed a major revolution of power by the European Court of Justice. In its claim that sovereignty of the European law was vested in the treaties, it declared itself the ultimate arbiter of the meaning of European law. The landmark case which sets forth the supremacy of the European law was Van Genden-Loos. The judgment established that EU constitutes a new legal order for international law, for the benefit of which states have limited their sovereign rights. The case established that the EU was the supreme body of law which prevailed over the entire body of national legal provisions. The declaration of supremacy was further expressed within the Costa case, whereby it was made clear that EU law cannot be overridden by national law. In the case of international law, the court stated as the EU is supreme and international law is to be interpreted in the light of sovereign law. The European supremacy was yet again reaffirmed further in the case of Smenethil, whereby the court declared national courts to consider all conflicting legislation as automatically inapplicable to conflicting provisions of current national law. Despite supremacy not being declared in treaties, the absence of supremacy would mean EU treaties' objectives cannot be attained. The treaty objectives would be threatened if the application of the EU law was allowed to be varied between member states, as national law would trump EU law and it would become a case of which member states is more sovereign. Once the UK joined the European Economic Community, which later became the European Union, UK Parliament passed the European Communities Act 1972 in order to incorporate EU law into the UK legal system. The main aspect of this Act of Parliament is in Section 2, providing that provisions under the treaties are to be given legal effect without further enactment. The European Communities Act acts as the gateway for EU law entry into UK legal order, and so it may be argued that through the development of the legislature, UK have fully accepted EU law doctrine of supremacy, thereby enabling the development of the doctrine within member states. The European Communities Act giving effect to EU law supremacy is said to be in accordance with the dualist approach. Sovereignty in the UK lies at the heart of the Parliament. Parliamentary sovereignty is the principle that makes the Parliament the supreme legal authority in the UK, which can create or end any law. However, since the UK decided to join the European Community in 1973, when the European Community Act came into force, the notion of UK parliamentary sovereignty has been altered. The European Community Act required that the UK Parliament must make laws which are consistent with EU law. This makes it very clear that the doctrine of parliamentary sovereignty have been undermined by the European Community Act. The community law prevails over national law whenever there is any inconsistency between the two. That directly undermines the principle of parliamentary sovereignty. In other words, it says that the Parliament is no longer the supreme legal authority, as certain provisions of the European Community can override its decision and influence the legislative process. Although community law affects the doctrine of parliamentary sovereignty, the principle of supremacy is an unwritten rule of community law. It only evolves under the jurisprudence of European Court of Justice. Conflicts between community law and national law were evidential and expected to happen. The idea of community law taking precedence over conflicting laws in the member states will, in the long run, pull away much more control of the member states' domestic laws to EU Parliament. This will only empower the EU more and not the member states, as their policies, laws, economy and security are all influenced by the EU's decision. The extent of the EU's control ultimately leaves member states' sovereignty at risk. As external laws intrude, the member state laws change, and that is the change which affects the people at country level, from government to public and private organisations. EU law at large affects almost every aspect of UK law. There are primary sources of EU law and secondary sources. The main sources of primary law are the treaties establishing the EU, while the secondary sources include the regulations, directives and the decisions of the Commission. In order to better understand which EU laws have influence over domestic law, it is best to understand the difference between directly applicable and direct effect. Directly applicable laws are the laws that become part of member state law, regardless of their approval or enactment of any further legislation. Direct effect is a provision of the European law which is directly effective if it creates rights upon individuals whom may rely upon their national courts and which are enforceable by those courts. Direct effect can be vertical or horizontal. Vertical direct effect means you can use the EU provisions against member states, whilst horizontal direct effect is more concerned with the rights to use EU provisions against another individual. The principle of direct applicability is set out under Section 2, subsection 1 of the European Community Act, meaning that all directly applicable EU law is automatically part of national law, whether it exists or not. Member states do not have to enact further legislation for it to come into effect. This puts the sovereignty of British Parliament into question. Does the UK really have sovereignty, as the Parliament has no say whether they accept or reject law? This goes against the doctrine of parliamentary sovereignty, as the UK Parliament is no longer the supreme legislative body, as they are left with no choice but to accept directly applicable EU laws. Furthermore, if directly applicable laws conflict with UK Acts of Parliament and conflict rises, the European law prevails over domestic law. So, what is Brexit? The word Brexit is a combination of two words, Britain and exit, which basically means the UK extracting itself from the European Union. On the 23rd of June 2016, the UK held a referendum on its continued membership in the European Union. 71% of Britain's population voted in the referendum, which resulted in 52% to 48% for Britain to leave the EU. Many who voted Brexit felt that if Britain was to leave the EU, it would protect and revive the country's identity. By identity, we mean Britain's culture, independence, and its placement worldwide. However, there are concerns that leaving the EU will diminish the UK's economy. Article 50 is invoked when voluntary withdrawal from the Union occurs. This article in the Treaty on the Functioning of the European Union grants the right to any member of the EU to exit. Article 50 addresses the procedure a country must take in leaving the Union. It gives the leaving country 2 years to negotiate an exit deal, and once it's set in motion, it cannot be stopped except by unanimous consent of all member states. No country has ever left the EU before, and there was no way to legally leave the EU before the Treaty of Lisbon that was signed in 2007. Prime Minister Theresa May triggered Article 50 shortly before 12:30 p.m. on the 29th of March 2017. That moment marked the beginning of a 2-year battle to thrash out a deal for leaving the EU, a process that is proving to be lengthy and complicated. Any deal must be approved by a qualified majority of EU member states and can be voted by the European Parliament. The process is supposed to take 2 years, but many people believe that it could take longer. The timescale can be extended, but only by the unanimous consent of the European Council. so every other member state government would have to agree. Triggering Article 50 starts the clock running. After that, the treaties that govern membership no longer apply to Britain. Following the outcome of the referendum, the most important piece of UK legislation that needs to be repealed is the European Communities Act 1972, which provides for the supremacy of EU law. Repealing the European Communities Act will bring an end to the constitutional relationship that exists between EU and UK law. Moreover, the vast amounts of secondary legislation that have been passed with the objective and justification of implementing EU law would have to be considered by the government. Parliament has legislated to repeal the European Communities Act 1972 with the European Union Withdrawal Act 2018, which will convert all existing EU-derived law into domestic law. The government's approach will allow the UK to decide over time what laws it wishes to retain and intends to avoid the significant gaps and consequent uncertainty if all EU-derived law was repealed without replacement. If the UK decided not to retain any EU law, companies looking to trade in the EU would still be required to comply with EU laws, such as the EU competition rules, regulations and standards. The UK will need to address EU provisions which regulate the relationship between EU member states themselves and also give extra thought to other issues such as legislation which relies on an EU regulator or give jurisdiction to the European Court of Justice. The numerous treaties which have been signed by the EU and are currently directly applicable in the UK by virtue of Section 2, subsection 1 of the European Communities Act. And the fact that references in the EU laws to actions being taken within the EU will not cover actions taken within the UK. The EU Withdrawal Act contains wide-ranging powers to amend EU-derived law by secondary legislation. In the government's view, these powers will give sufficient scope to correct or remove laws that would otherwise not function properly after Brexit. Although the government has sought to stress that the powers will not be able to be used to create new policy. There are, however, concerns about the time which may take for the legal separation of the EU and UK law, as it is set to take up to a decade to sort out. As constitutional law expert Richard Gordon states, you cannot simply cut and paste. So, what will be the impact on existing European directives? EU directives require implementation into UK law in order to have effect. This creates the task for UK government reviewing Acts of Parliament and statutory instruments and deciding whether or not to maintain, replace or repeal each piece of legislation. The European Union Withdrawal Act intends to affirm the status of UK legislation passed in line with EU directives. However, much of this legislation will need to be amended to take into account the new relationship with the EU. So, what will be the impact on existing European Union regulations? EU regulations are more powerful legislative tools than EU directives. Due to their immediate applicability, they are directly implemented into UK law without the need for legislation from the UK Parliament. The status of existing regulations will be addressed in the European Union Withdrawal Act. However, amendments will likely be needed to take into account the UK's new relationship with the EU. So, will the UK courts still be bound by the decisions of the European Court of Justice? The European Court of Justice in Luxembourg is the final authority on the questions of the interpretations of the EU law. On the 17th of January 2017, Prime Minister Theresa May, in her first speech setting out the UK government's priorities for Brexit, stated that the UK is not prepared to continue to be subjected to the jurisdiction of the European Union Court of Justice. The EU Withdrawal Act sets out the future relationship between courts in the UK and EU law, including EU court decisions. All UK courts, apart from the Supreme Court, will continue to be bound by the EU laws and court decisions made before Brexit. The European Union Court of Justice decisions have influenced many areas of English case law, and the English courts have looked at the wording of EU directives for the purpose of understanding UK legislation, which was passed to give them effect. However, it is likely the UK courts may start to move away from such decisions once the UK is no longer bound by EU law, or such decisions may be replaced by post-Brexit legislation. But in the meantime, the interpretation of EU law is likely to continue to play some role in English jurisprudence. LawLeeks is produced in association with Birbeck University. This episode of LawLeeks was made for the understanding of what Brexit would mean for UK parliamentary sovereignty. Please make sure to like and subscribe to the LawLeeks YouTube channel for more videos.